Today we will discuss on vicarious liability under specific legal issues and ratio decidendi and obiter dicta. Okay, these topics will be discussed for today's session. So vicarious liability, it means second-hand liability. You have direct liability and then you have the word vicarious. Vicarious means indirect or second-hand. Secondary, derivative, derived, these all are synonymous with vicarious. Okay. So in direct liability, if you do something wrong, you are responsible. But in vicarious liability, if you do something wrong, the employer or someone else, a second party, is responsible for your wrongdoings. That is vicarious liability. Okay, so vicarious liability or imputed liability is a legal rule that holds a person or a company responsible for the actions committed by others, or specifically their employees. Okay, typically it applies to those who are in control of the people who cause harm to the victims. For example, hospital. Hospital, who is in control of the people who can treat and diagnose? It's the hospital administrators. Who are the people who can treat, diagnose, or have a potential to cause harm? It's the doctors, it's the medical clinical staff. Okay, they have the potential to cause harm. Okay, who are the victims here? Patients. Patients are the victims here. Okay, so in vicarious responsibility of a hospital, the hospital administration, the top management will be, or the hospital itself will be held responsible, okay, for the actions of their medical team, healthcare team, or clinical team, okay, for the harm that is caused to the patients, clients, visitors, etc. Okay, so it's on page number 145 in your medical legal textbook, page number 145. So example, a hospital is held responsible for the negligent acts of the employee. This is vicarious liability, second-hand liability. Okay, the person who have done the crime is not responsible, but the person for whom this negligent person works for is responsible. Okay. So there are certain terminologies under vicarious liability. We will discuss each one of it. One is respondent superior. Okay. So this is again a doctrine which is used to fix the responsibility, who is answerable for whom. So the basic meaning of respondent superior is let master be answerable. Let the master be answerable. Okay. So here the master, when we talk in layman terms, when we talk, who is the master here? Definitely the hospital administration, hospital owners, senior management. Okay, these are the masters, will be responsible for the actions done by their inferiors, okay, or subordinates. So the before respondent superior should be put into practice, there are certain things that has to be proven. Okay, the first is the relationship between an employer and an employee must exist. Okay, and with the primary tortfeasor is the person who did some negligence. Okay, that is a doctor. Let's say take a doctor for an example, a doctor who has been accused of medical negligence. Okay, that's a tortfeasor. Tortfeasor is someone who has contributed to a crime, who has took into action of a crime. That is tortfeasor. Okay, being an employee, and the party sought to be held vicariously liable is the employer. So there is a relationship that has been developed here. The employee has committed the crime. Okay, and there is an employer who had hired the employee to do certain job. Okay, so there is a relationship has been established. Okay, the first thing is done. When the employee committed the underlying tort or the underlying mistake or medical negligence, he or she must have been acting within the scope of their employment. Okay, for example, during an OPD visit, during the OPD hours of the hospital, some medical negligence was done. Okay, done onto a patient. Okay, so the time at which this medical negligence took place is definitely under the scope of employment. Okay, for example, you can answer in the chat box. You can answer in the chat box. Let's say a doctor was traveling. Okay, at a traffic signal, something went wrong. Some accident took place. Doctor went to save the patient or save the person who was in the accident. Some negligence took place on the part of the doctor. Okay, and it was proven in the court that it was a medical negligence that the doctor had done during the or this person had done on in the traffic line. Okay, some medical care was given, but it was a wrong kind of medical care. Okay, and this happened in a public area, a traffic signal. Okay, will the hospital for which the doctor is working, will the hospital be liable here in this situation? You can answer in the chat box. The doctor was on the way to his job. Will the hospital be held responsible in this situation, or will the employer of this doctor be held responsible? Will not be, because the act that the doctor had carried out was out of the scope of their employment. Okay, whatever happens within the hospital, or if the hospital is conducting a medical camp, let's say another example. Okay, the hospital is conducting a cataract medical camp. Ophthalmologist went there and performed a lot of cataract surgeries. Lot of cataract surgeries went wrong. It did go wrong. Okay, people lost their eyesight. Okay, complaints of people losing their eyesight after this medical camp was held. Okay, so who is responsible here? Is the doctor responsible, or is the management is responsible? In the second example of a medical camp held by a hospital. Here, the hospital will take the liability because it was under the supervision, okay, under the sources that the hospital has given. Okay, sometimes the doctor was skilled, but the kind of amenities that was provided towards this medical camp was of defective quality or something like that. So who is responsible? Definitely the management is responsible. Okay, so if the employee has committed any negligence or tort during the time they were under the scope of their employment, they were doing this tort or medical negligence during their official duty hours within the hospital or within any arrangement led by the hospital. Okay, the hospital will be vicariously responsible. Okay. Then we have the terminology perceptor. So perceptor is vicariously liable for the acts or omissions of the students. For example, if you're a nursing student, medical student, your teachers are responsible for your wrongdoings. Okay, because students have not received their medical license or practitioner license yet. But the teachers, the lecturers, your clinical instructors, they can lose their license over the acts or omissions conducted by the student. So that is the preceptorship. Preceptorship. That is the terminology, preceptorship. And the person who is a preceptor is the person who has the liability, vicarious liability on them. So preceptor is responsible for teaching skills to the students. Okay, if the students do something wrong on patient or during their student nurse or student doctor hours during their internship even, okay, the preceptor will be held responsible for the actions of the students. Okay, so this is also another form of vicarious liability. Wrong was done by someone else, but A and B, A had done the crime or A had done the tort or negligence, but B will be held responsible. But if the relationship between A and B is a teacher, student, mentor, student, okay, a clinical instructor, training manager, student kind of a relationship, preceptor will be held responsible. Then we have proctor. Proctor is a person who supervises or monitors doctors as the doctor is doing an examination, okay, or treating or doing diagnosis. There will be a person, there will be a much experienced doctor who will not treat the patient, but they only supervise and they monitor what the doctor is doing. That's a proctor. Okay. And there are certain elements that proctor should be careful about. The proctor should not come across as a senior physician to the patient. Okay. Because the patient may think that the two doctors are present here. Okay, obviously the older doctor, the much experienced doctor will be the senior physician. The person whom I'm talking to, who is examining me or who is consulting me, is the junior doctor. So that kind of relationship should not be established. Okay, the proctor has to clarify that the role they have in this meeting is just to examine the doctor. It's not to examine or treat the patient. Okay, and the proctor should not introduce themselves as a treating physician even. Okay, they should not introduce themselves that I will be your treating physician or I will be your senior physician. They should not do that. Okay, they should clearly, in the first setting itself, they have to establish that I'm not here to treat you, but I'm here to monitor and supervise this doctor. Okay, so that's the proctor relationship. So even if the doctor commits some crime or commits some medical negligence under the supervision of a proctor, the proctor will be held responsible. Then who is an employer? Under vicarious liability in Indian courts, Indian legal framework, what do you mean by an employer? So employer has certain rights. Okay, employer has the hiring and firing authority. Okay, anyone in an organization who has the hiring and firing authority becomes your employer. Okay, it's not necessary the owner. Okay, for example, let's say Infosys. Okay, do you think Mr. Narayan Murthy is the person who is hiring and firing people in Infosys? Definitely Narayan Murthy is the founder. Okay, Sudha Murthy, Narayan Murthy, both are the founders. But are they involved in the hiring and firing of the people under Infosys? They are now they are basically the founders of Infosys. Okay, they are not. Okay, they are not involved in the hiring and the firing of the team. Okay, that is a different team. Okay, that team will be liable for the trainees or the interns whom they have inducted into the program. Okay, so not necessarily if you own the hospital or if you are the owner, you will be responsible for the acts and deeds of the doctors. Okay, it's not always the owner who is the employer. Okay, employer has certain principles, some ethos, some working policies in place, some legal framework that they have to follow, which the owner does not have to. Okay. Senior members in the management position can also be held as vicariously liable. Okay. Then administrator. Administrator is responsible for the compliance to legal requirements. Hospitals have a lot of registrations. They have to renew on a yearly basis, for every 3 yearly, 5 yearly. Okay, licenses they have to take care of. Lots of licenses go into building a hospital. Okay, legal compliances with Biomedical Waste Management Act, Drugs and Cosmetic Act. There are so many acts that a hospital has to be compliant of. So the administrator is make sure that the institution is complying with all these legal framework of the country they are performing in. Okay, they are responsible for credentialing and privileging of the subordinates. Okay, which doctor is given credit of what kind of work. Okay, doctors' privileges. Okay, honorariums, etc. Infection control courses, patient safety practices. To ensure all these things, administrator is responsible. Okay, and not just the top administrator. If someone is a head of the department, okay, specifically clinical department, okay, there will be head of surgery, head of trauma, head of ophthalmology, head of orthopedics. Okay, every clinical department, if it is a multi-specialty hospital, every clinical department will have certain heads. Okay, they can also be considered as administrators. It's not only the top management people who work in the non-clinical firm Not just that, even in the clinical area, you will have administrators. Okay, consider all head of the departments, clinical departments as administrators. So some examples of court judgment. Okay, so there was a scenario in which happened in 2003. Okay, Mr. Ramesh Reddy versus the state of Andhra Pradesh, where an obstetric patient, okay, a wife of Mr. Ramesh Reddy, uh, fell in the bathroom and she passed away. Okay, she was pregnant, she fell in the bathroom and she passed away. The court held hospital authorities responsible because it was the responsibility of the hospital to keep the bathrooms clean and slip free. Okay, the bathroom was covered with that green fungus, okay, which is like if you step on it, you're prone to slip and fall. Okay, so the hospital bathroom was had a lot of green fungus. It was slippery. The patient went into the bathroom, she fell and she passed away. And compensation was awarded to the husband. Okay, so it was not the hospital authorities' duty to clean the bathroom. It was definitely the housekeeping department's job. But the housekeeping department, whom will you find liable here? Okay, because the hospital administrator had to ensure that every part of the hospital is clean, it is safe for patients. Okay, if you see the IPST, International Patient Safety Goals, uh, patient falls, okay, prevention of patient falls is one of the main 6 goals. Okay, that is for patient safety. This hospital failed in conveying their duty of patient safety. Okay, specifically their risk of patient falls was not taken care of, so the hospital is responsible. So under that grounds, compensation was given. That is one example. Second was Jose Papachan versus and ORS versus Dr. George Munjeli. It was a 1994 case in which the wife, a lady, passed away after postpartum sterilization. Okay, after giving birth, sterilization was done. Okay, to prevent future kids. Okay, during that operation, uh, some mismanagement took place. It was not a clean operation, but because of certain severe symptoms, she was taken to some other hospital, where when they did their examination, it was understood that the lady has intestinal perforation, and because of which the feces, okay, it went into the peritoneum and it caused inflammation. Okay, the patient did have peritonitis, fecal peritonitis, because of the perforation that took place in the intestine after the postpartum sterilization operation, which means that medical negligence was there. The operation was not performed well. Okay, so the court concluded that the hospital management, where the operation was done first, okay, is vicariously liable for not providing adequate facilities for anesthesia and clean environment for surgery, and because of which the patient passed away. Okay. So what to do with so many judgments? It is very difficult for hospitals to avoid these vicarious responsibilities. How can they safeguard themselves, okay, against the cases of medical negligence? So display the relationship. Okay, the hospital has to clearly display the relationship with doctors who are not employee of the hospital. Okay, some doctors are just private practitioners who come to the hospital. They they have that private clinic somewhere else, but they do conduct regular visits to certain hospitals. So those are independent practitioners. They may have their own clinic, but they also give their honorarium. They get their honorarium from hospitals just after conducting training or workshops or just visiting the patients. Okay, or they may be just giving their OPD hours. Yeah. So though the actions of those employees are not related to the hospital. Okay, so the hospital has to display that clearly. Independent practitioners should have their own letterhead. Okay, hospital should encourage writing all the institutions where that independent consultant practitioners should be separate on their letterhead, to make clear that this hospital is not responsible for the actions taken by this doctor. Okay, letterhead will usually have the patient's private practice information, but not much about the hospital's information. Okay, so you have to be careful with the letterhead that you print for specific doctors. Okay, do not collect charges or fees which comes through independent practices. And always keep monitoring the performance of the physicians, and wherever correction is required, take necessary actions. You have to be very rigorous as a hospital administrator. You have to be very rigorous in credentialing the process of doctors, including the competencies of consultants. How many years of experience do they have? What skills do they have? Okay, how well are they? How well do they perform in their specialty? So these all are credentialing. Okay, you have to be very. You don't just give away credentials to everyone. They have to prove their merit only after which credentialing can be done. Employee trained professionals only, trained, educated, and skilled and experienced staff only. Standard operating procedures are documented. So if it is documented specifically for high risk areas, okay, every patient management procedure should have an SOP, and see to it that every practitioner is following that SOP. Okay, you have to monitor that if the SOPs and the protocols are being followed or not. It should not be just namesake documented bunch of copies. Okay. Next topic, ratio, Decidendi, and Obiter Dicta. Okay, so both is just the meaning of both of these situations are identical, but is it used in the judgment or is it not used in the judgment is the key difference. I'll explain you why. A judicial statement of what we commonly refer to as a judgment in a legal case consists of two elements, which are referred to as ratio Decidendi or ratio or obiter dicta, or called, in short, we will call as obiter. Okay. So ratio in Latin means that the reason of a court's judgment. Why did the court judge in this way? What was the reason that the lawyer or the judge had mentioned that I am giving you this punishment, or you have to give this compensation, this much amount of compensation because of the reason. Okay, rational. The rationale behind every judgment is called ratio. Okay, while obiter usually refers to the additional opinions or observations that are made of the issues that are involved in the case. Okay, obiter is just opinions or statements, but they do not have any role in passing the judgment. Okay, because of obiter you got this much years of imprisonment, because of obiter you got this much compensation to pay or this much fine to pay. Doesn't happen. But because of ratio, these things will happen. Okay, judgment was passed because of so and so ratio. Okay, obiter are just additional statements and opinions which and facts that are discussed in the courtroom. Tomorrow, again, the same case happens somewhere else. Obiters can be used as a persuasion. Okay. So obiter very often reveals the rationale that the court has adopted to come to a conclusion, but it is not at all binding the judgment. Okay. Obiter are the statements that the judge has given additionally, but the judge will not use those statements to give you punishment or give you the judgment. Okay, obiters are just mere statements which has to be discussed, which should come up, because tomorrow in the future, if a new case takes place under the same grounds, on the same levels, obiters are used as persuasion techniques by the lawyers to fend their case. Okay, so obiters, because of obiters, you will have few more additional years or few more less years, or you may have to pay extra for fine. Never takes place. It's only because of ratio. Okay, ratio of a case depicts what kind of judgment is passed. Obiters are just mere additional opinions and statements. When I will give you the example, you will understand the concept of both of this. So ratio Decidendi in detail, we'll just go through it. The reason is in this regard is not merely applying the law to the facts and coming up with an order. Okay, you are not just putting law or giving a judgment because of certain facts. Okay, ratio instead refers to the steps that are involved to resolve a dispute. Okay, how to solve it. You require rational, you require reasoning to it. Okay, if a dispute is going on, you have to resolve it. That's the uh, duty of the court. Okay, so what all facts, what all orders, okay, what all statements they use to dissolve this dispute or to resolve this dispute, that becomes a ratio. Okay, this resolution must be directly related to the issue or issues that are at the core of the dispute. Okay, so when you're discussing, there is X versus A versus B case. Okay, the main reason that led into this dispute, those things are discussed. Okay, and the ratio will be around that particular core reason. Okay, you will not take examples from other cases, or you will not take previous dictums to come to a judgment. Okay, you will take this court case as a very subjective matter. Okay, you will observe it keenly. Why did this dispute take place? And because of that, why, you will come to a judgment. It comes from the disputes of law and not disputes of the fact. Okay, some loopholes may be there in the law, and when you are discussing that loophole, when you are finding answer to that loophole, that's when a ratio decidendi arises. Okay, it's not because of the disputes or the fighting because of the fact. Ratio decidendi must be argued in court, and the facts of the precedent case shape the level of the generality to which later courts decide the level of generality. Okay, for example, let's say the Nirbhaya case that took place. Okay, Nirbhaya case is the precedent case. Precedent case, it was first of its own kind of case. Okay, so in future, if at all, unfortunately, any other case that takes place, which is very similar to what happened in the Nirbhaya case, okay, it comes under ratio decidendi. What all judgment will be passed in that new case will be also in the same line of the judgment passed for Nirbhaya. Okay, so that is ratio decidendi. The grave sins committed during that case, or during the grave facts that are present in that case, if both of them are quite similar, okay, then a general law, general judgment can be passed. Okay, but there should be a precedent case uh, which is very similar to the case that is ongoing right now. Ironically, when precedent has multiple reasons, all reasons are binding. There were many multiple factors that were discussed in the previous cases that gave a particular judgment, and those multiple factors are also seen in this case. Okay, today's case also, the same multiple factors, if they are seen, okay, you can approach it as a ratio decidendi. Ratio becomes very powerful tool in the hands of the lawyer, and that is why it becomes essential for him to comprehend it well. Okay, the reason becomes a very powerful tool. For whoever is your lawyer, defendant or plaintiff lawyer, okay, the reason becomes very important. The intention becomes very important to see the course of the judgment. To find the ratio in the judgment, one looks at abstract principles of law that have been applied to the facts of that particular case. Then we have obiter dicta. Obiter is the term used for remarks made by the judge, which are not binding on the parties to this case. These are just remarks, opinions, and statements. Okay, statements that are important, but it does not have any role for the judgment. Okay, whatever judgment has passed, it is passed. But these statements and opinions have no role in changing the course of judgment. Okay, statements that are not crucial and are referred to hypothetical facts or issues of the law not related to the case also form a particular part of obiter dicta in the judgment. So it's not always that whenever a obiter dicta has been given by the judge, it's not always relating to the case that is currently being fought. Okay, some examples and some statements from previous cases or some other situations can also be borrowed to be used as an obiter dicta, to be used as an opinion in this case, but this opinion will not uh, guide the lawyer to make a judgment. Unlike ratio, obiter is not the subject of the judicial decision. Even if the statements made in this part are correct according to the law, obiter can never be the subject of a judgment. Okay. Bamberg's inversion test provides to determine whether a judicial statement is a ratio or an obiter. You should invert the argument, like whatever argument is used to win the case, you have to invert it and say that you have to ask a question that if this statement was not used, if the statement was omitted, will the decision be different? Okay. If so, if a given statement, if the judge statement, okay, if because of this, I am passing this judgment. Okay, because of XYZ reason, I am passing this judgment. If the judge say like this, okay, if that statement, XYZ statement, if it was something different, will the punishment or will the compensation or will the judgment be different? If yes, if the XYZ statement was not used and the judgment would have been completely different, then that statement is a ratio. Okay, but even if the XYZ statement was used or not used, the judgment would have been the same. Okay, if that is the situation, then that XYZ statement is an obiter. Okay, so ratio, what can we conclude here? XYZ, okay, to see that if XYZ statement is a ratio or obiter, ratio has the power to change the course of judgment. Obiter does not have the power to change the course of judgment. Okay, a judge's judgment can change on a statement, then it is a ratio. If the judge's judgment will not change at all, even though whatever is the statement, okay, that is an obiter. That statement is an obiter. For example, there is an example in your textbook as well on page number 149. Third example, a couple leaves their dog in the car while they go out for a shopping. Okay, something happened and the dog got very excited. It starts jumping around inside the car, and the dog was not suffering from any dehydration or it was not overheated because the couple uh, didn't uh, uh, didn't take long to shop. Okay, but something went wrong and the dog got so excited. Dog started jumping around, and unfortunately its hand went into the rear glass window and it shattered. Okay, the rear glass window shattered and the glass shards flew off, and somebody was walking past by, some commuter was walking past by this car. At the very same time, the dog was shattering the glass window, the rear glass mirror, and the glass shards from that rear glass mirror, it went into the eye of the commuter, and that person had to remove that eyeball. Okay, he got the passerby had to remove the eyeball. Okay, because of the because of how excited the dog got for no reason. Okay, so the person who lost his eye had sued the couple. Okay, he said that the couple should give me the compensation. Okay, so but the court said that the couple is not responsible because they went out for shopping. The dog was completely safe. The dog was not in a situation where it was locked up, dehydrated, trying to save for his life. It was not a situation like that. The dog had enough air and ventilation, but for unknown reason, the dog got excited, and because of the dog's action, the glass broke and it hit the commuter. Okay, the couple who went out for shopping for a few minutes, they cannot foresee the situation. Okay, who must have thought that if I leave my dog inside the car, it is going to cause harm to someone outside. The dog was inside the car. No way the dog could cause any harm to an outsider. So this was an unforeseeable situation. Nobody could have predicted that things can go wrong in such a way. And the dog usually was not the kind of a dog that used to get excited. Okay, it was a normal dog. So the couple had no idea that this kind of fantastic opportunity can take place. It's called fantastic possibility. Okay, a fantastic possibility means you cannot foresee that things can go in such a way. Okay, so this was so for this reason the decision was a ratio Decidendi decision. Therefore, when harm was caused to a pedestrian by a dog smashing the window of a car, it was in where this kind of incident is unforeseeable. The defendants are not liable. Defendants here were the couple, the owner of the dog. They are not liable to pay compensation or charges for a person who lost their eyesight. Okay. But additional statement here in this case, the judge made an additional statement. Okay, and that statement was, because the couple did not have a dog which was known to be excitable. Some dogs have an excitable temperament. They are not shy. They are not quiet. Some dogs are naturally quite excitable. Okay, they have naturally high energy. It's very hard to keep up with them. Every dog has their own personality. Okay, only the owners would know. Owners and the neighbors would know what kind of personality this dog has. Okay, so naturally it was known that this dog does not have an excitable temperament. Something at that point of time, something went wrong and the dog got excited. That's it. It was once in a blue moon kind of situation. Okay, but if in future any couple knows that their dog has a very excitable temperament and they chooses to leave it inside or leave it in a situation unguarded and it causes harm to someone else, then the owners will be responsible. The owners of the dog will be responsible for the harm caused. But in this situation, owners had no idea that the dog will become excitable. The dog does not have that kind of personality and something went wrong. Here the owners are not responsible. But in future, if you are an owner of a dog and you know the excitable temperament of your pet has the potential to cause harm to others, and it came true, it did cause harm to others, then the compensation could have been paid. So that's an obiter. Okay, but if in future the same situation happens to someone else who knows the idea of their dog, who knows the temperament of their dog, and something went wrong, then the compensation could have been given. So that statement is an obiter. Okay, that statement is just an additional opinion. Okay, that can be used in future similar cases. Okay,